The petitioner brought an eviction petition against the respondent number 1 bracket the respondent bracket clause under the Punjab Rented Premises Ordinance 2007. Hereinafter be referred the ordinance, in which the letter appeared before the Rent Tribunal on 26/2/2008, The case was adjourned to when leave application was filled by the respondent, which was beyond the period of 10 days are required under section 22 bracket 2 bracket clause of the ordinance, thus confronted with the above, the respondent moved an application on 28/4/2008 seeking condonation of the delay on the ground that there is no fault on petitioner's part and even on the part of the petitioner's counsel, it was just bona fide mistake of fact which has caused no prejudice on other party, as the petition was fixed for 8/3/8 and no development proceedings could be made before the date in any case. Hence it's just a technicality, nothing more, full stop. It is also stated that the apex court encouraged the disposal of litigation on merits and not on mere technicalities, full stop. Be that as it may, the Land Tribunal wide order dated 21/7/2008, by rejecting the application for leave to appear and defend the order seeking condonation of delay, passed the eviction order and directed the respondent to vacate and hand over the vacant possession of the dismissed premises to the petitioner within a period of 2 months, full stop. However, strangely, the tribunal still framed the two issues by stating that since the parties are at variance on the issue of period of default and an amount of arrears of rent, therefore, out of the divergent pleadings of the parties, following issues are hereby framed, full stop.